If we reach the end of the allotted hour and we still have some questions to answer, we will stick around. So if you're able to, please do so. And Jim Carlton will be monitoring the Q&A box to make sure we see all the questions and try to get to everybody in sequence. And comments as well as questions are welcome. And again, if you haven't muted your phone, go for it. I want to just start by saying a couple of words about Reclaiming Futures. For those of you who don't know what we are first and foremost a national learning community. We have implemented our what we call a public health model for juvenile justice reform and various practices and frameworks that are associated with that in 45 sites around the country since our inception 17 years ago. We're in 22 states now, and we see ourselves also kind of as an innovation laboratory, and that's kind of apropos to this particular webinar. We're featuring the project director from one of our sites in rural northern Ohio to highlight some interesting and innovative work that they've done that's been sort of part of their evolving approach to working with young people and families in the courts. So all of our work at Reclaiming Futures is not top-down. We also consider this a grassroots, kind of bottom-up innovation organization that listens to and learns from our sites around the country as well. And we look forward to hearing from Jerry Stollings later. We also have developed a number of practical tools that jurisdictions around the country, including school settings. Recently, we've forayed with some of our screening and brief intervention and referral to treatment work into school settings. And so, among other things, we are also a developer of practical tools that you can use. We're available for coaching and technical assistance for jurisdictions around the country who are looking to improve outcomes for their young people and families. We work in county and state jurisdictions as well as tribal communities. Our national longitudinal evaluation has demonstrated significant improved outcomes as well as cost savings when the Reclaiming Futures strategies are integrated with treatment courts. And at the bottom of this slide, you'll see a link to the University of Arizona's webpage they set up to report out on all the findings from their longitudinal study of Reclaiming Futures. There was a comparative study of Reclaiming Futures attached to juvenile treatment courts against a cohort of treatment courts that did not use Reclaiming Futures. So if you, after today's webinar, are interested in learning more about our results, please go to the University of Arizona website, hit the link below. And we'll make this PowerPoint available. There's a slide at the end with an email address you can send. We'll send a PDF version of this PowerPoint later if you're interested. So to transition to today's webinar, I want to talk a little bit about the concept of therapeutic jurisprudence, which was introduced to us in the mid-'80s by a researcher named David Wexler. And in a nutshell, it's the challenge of counterbalancing the goals and considerations of justice and of juvenile court, in our case in juvenile court, to counterbalance concerns with public safety and the delivery of justice with the rehabilitative mission of the court and concerns for wellness and health and healing, and the challenge that that has been for us. It is no secret, those of you who are students of juvenile treatment courts and have read the literature, that the results evaluating the effectiveness of juvenile treatment courts have been mixed at best. The most recent study combining a meta-analysis combining all the available best studies looking at juvenile treatment courts concluded that they are not effective. But those of us who work on the ground know that pieces of what we do are effective, and there are some phenomenal courts around the country. So the field is kind of at a crossroads. We now know that therapeutic jurisprudence is not as simple as just counterbalancing two things, treatment and justice, that we have to consider issues of trauma, both historical and current trauma and adverse childhood experiences for the young people that we serve, issues of race, gender and sexual orientation, and apropos to today's presentation, the role of family and community as another lens that we have to see the work that we do with young people through. And with that, I'm going to introduce Jerry Stollings. Let me just say a word about Jerry. Jerry is a native of rural Northwest Ohio, graduated from the University of Toledo College of Law in 1999. Between 2000 and 2015, he practiced primarily criminal law before he became the court administrator for the Williams County Juvenile Court, where he still serves. And as Jim mentioned earlier, he's also the lead project director for the Reclaiming Futures initiative in Northwest Ohio. He also serves on a number of influential boards in the state of Ohio and has married with 4 teenagers. So you cannot doubt that he knows what he's talking about when it comes to adolescent development. And I'm going to turn it over to Jerry to talk about an innovative program that they've grown locally in Northwest Ohio. So I'm going to move the presenter status to you, Jerry, so you can advance slides yourself. And take it away, Jerry.
All right, thank you, Evan. Let me move forward here. First of all, I want to thank everybody for joining in on this call. Hopefully you can learn something from this, and I'll probably learn something in the process as well. I wanted to give you a little bit of information about where we are. You can see on the map that we occupy the northwest corner of the state of Ohio. We border Indiana and Michigan. We have a population of about 38,000. With the county, Bryan is the county seat, and Bryan is the home of Ohio Art, which created Etch-a-Sketch, and Spangler Candy, which makes Dum Dum Suckers. The city has a population of about 8,500. We have 7 school districts, and we're fortunate that we work pretty well with all of our school districts, especially in some of the projects that we lead. Family Intervention Court is our specialized docket court as certified by the Supreme Court of Ohio. We've been certified by the Supreme Court since approximately September of 2015. The way the court is designed is we take a maximum of 10 cases, and they're both from our dependency and delinquency dockets. They're organized around a treatment team. And I'll talk about the treatment team in a couple of minutes, but it's an 11-member team from various areas of our community. But this was this came about as a result of a planning committee, an oversight committee that worked for about 2 years before launching this, and admission is granted by the treatment team. So that's kind of a little bit of background. The reason that we came up with this idea, or the reason this idea was generated, is we noticed that there was a strong link between delinquency cases and dependency cases. I think anybody who's worked in the juvenile court will recognize that oftentimes we'll have a delinquency case where the kids were at one time the children in a dependency case whose parents were delinquency cases 15, 20 years prior, who were also dependency cases, and so on and so forth. And kind of the cyclical nature of what happens is something we wanted to step in and stop, if at all possible. We wanted an approach also that allowed us to really get at the cause of why the case was on our docket to begin with, whether it be a dependency case or a delinquency case. Because if we don't deal with the cause, then nothing ever changes. And we didn't really find a framework out there, a model for a court system that addressed those issues and addressed the kind of multi-generational nature of what we deal with, especially in rural communities where we can see these families come through. I have a probation officer who's been on staff for 20 years, and we'll have a kid come through and she'll talk about that she had their parent on probation. Our judge has been on the bench for 21 years, and he has seen multiple cases from same families being delinquency, dependency, delinquency. And so denying the multi-generational aspect of what was going on was really not going to help the situation here that we were dealing with, and there was really no model for that we could find. The reason we didn't create multiple courts is somewhat practical because of the size of court we have, but also what we noticed is that the family-centered approach can really help with the issues regardless of what brought them to the court to begin with. So, you know, you may have a child who is committing a string of theft offenses, and the family-centered approach may work for that family as well as a family that is dealing with parents who are abusing drugs and their kids have become dependent, or any number of variations of that. But rarely is it just a drug issue, or rarely is it just a mental health issue. Sometimes it's neither one. So the family approach, and I do want to note that when I say family, I'm talking household, using family in a broad definition. But when you're talking about family issues, rarely is it just a one single issue. And so this approach allows us to really center in on what's going on in the home that is affecting whatever behavior that is in the outcome of what is going on. And from a practical sense also, the volume level. We're not a large county, and if we had just a juvenile drug treatment court, we'd have maybe 4 or 5 participants. If we had just a family treatment court, we may only have 3 or 4, and it's just more practical for us all to work together as one team and tackle these problems the same, since we're using the same individuals to do the work. So why family intervention court? Primarily, we recognize the importance of working with an entire household structure. Again, just dealing with one thing inside the home doesn't really seem to help. You'll note on the slide that I put that an oil change is rarely all that's needed to help a poor performing engine. If you have an engine that's smoking and clattering and all kinds of stuff, and you go in and you change the oil, it may help the oil, but you still may drive out of the dealership or wherever you get oil changed with a poorly functioning engine. And that's kind of what it feels like we've done in juvenile court over the years, is we just changed the oil and nothing else. And looking at how these structures work, family systems theory kind of plays a big part in our approach, specifically Bowen's family systems theory, which deals with differentiated individuals versus fused individuals, as a multi-generational component. It's a theory that's based upon years of study of dysfunctional situations. So our goal is to interrupt that, and we really truly believe that if we can change the environment, we really can change lives. And that sounds a little bit like a pipe dream, but when we get to the end and you kind of see some of the results that we've had, I think you'll at least be intrigued by what's happening here. Another part of our focus is also that youth responds well when the focus includes their family. In our review hearings, we see some pretty amazing family communication take place that over the course of time that we didn't see before. Parents communicating about their children in more positive ways. Kids communicating about their parents in more positive ways. Sometimes when they would come in, there would be a combative attitude, and after they've been through the process for a while, there was a collaborative attitude between the 2 of them, or the 3 of them, or the 4 of them, or the 5 of them, however the case may be. And seeing that that the focus is more on the structure rather than just on that child's behavior or just on that parent's behavior, if it's a dependency case, kind of takes the kid off the hot seat and allows the system itself to heal, allows the environment itself to heal, and makes a positive impact on what these kids are doing, what these families are doing. So how does this work? These are kind of practical things, but I'm also going to talk about what the roles of the treatment team are. The treatment team meets every Tuesday at 2:45. We have a conference room here in the courthouse that we meet at. We have review hearings every Tuesday at 3:30. Sometimes we'll meet a little bit early if we have new cases to review that are going to be voted on to come into our program. The delinquency and dependency hearings are separate. We do not have them at the same time. That way we can deal with the issues that are particular to those types of cases in that setting. Our treatment team, the slide lists the different members of the treatment team. A lot of the roles for treatment team are defined by the rules of superintendents here in the state of Ohio. In order to go through in order to be certified by the Supreme Court, there is a rule that governs steps that we have to take, and we have to identify those roles in a program description that is then given to the Supreme Court to review, and then they come and watch us. So these roles are all pretty well defined by rule, and they function pretty well within the confines of the team. We have the judge, magistrate is also involved. Magistrate covers for the judge when the judge is not available and also provides a valuable voice. And just to let you know about our county, we have one juvenile court judge, we have one magistrate. So we don't have to worry about moving between judges for this. We have the one judge. Program director, which is myself, and I kind of oversee the operations of the Family Intervention Court. Then we have a program coordinator, which also kind of serves as a case manager. The program coordinator is the one who really does all the legwork whenever we are looking to bring somebody in. She's the liaison with all of our treatment providers. She is also the liaison with our team members, treatment team members, and she's lead contact with a lot of the families. She gets pretty heavily involved in what's going on in their homes. Our chief probation officer is our probation person for delinquency cases. We reallocated our staff and moved her with her supervisory role, and then also that's all she does is probation for these cases. And I use the term probation kind of loosely. It's not a probation as you would traditionally think of it. She spends a lot of time with the case managers. She spends a lot of time with the families. She spends a lot of time going to the schools. It's a very intensive probation, but it's not intensive supervision. It's more intensive involvement in what's going on in the child's life. A really good example is, and I can talk about this later on, but I kind of want to bring it up now just because I like it. We had a child who was going through our program right now, started out pretty rough, ended up going into residential drug treatment, came out and is now excelling as a student, won a talent show at his school, and the probation officer had she wasn't able to go to the talent show, but the video was emailed to her. She was able to follow up with him, and they're involved in things like that you know, good probation officers tend to be involved in. We have a diversion counselor that is included. She is a licensed therapist. She does not perform licensed therapy for us, but her input is invaluable in what she provides to the team. Prosecutor is an active participant. Our prosecutor's office has been an active participant in this since the planning stages. We have a representative from our defense bar who is a named member. It's just one person who comes. For the people on the legal side, his relationship with the families and individuals, it gets somewhat complicated, and we've had to be pretty specific in our agreements and how this all works. We have a dual diagnosis counselor, one that does substance abuse and mental health counseling. We have a mental health counselor. Both of them, we use their agencies quite a bit, but they're not the only agencies that we use. We also have a children's services caseworker. The caseworker is the lead on the dependency cases. If you go back to the chief probation officer, she's the lead on the delinquency cases, and the caseworker from children's services is lead on the dependency cases. The program coordinator operates as case manager for both of them, but they have different leads. That's kind of how that part of it works. Now, the legal criteria, and I just noticed something on here that shouldn't be here, but they're a member of Williams County. It says that they're charged with delinquency, unruly, abuse, neglect, or dependency, but unruly cases do not come in. So that is a typo on my part. They must be eligible for probation, must be a misdemeanor felony charge, and under the age of 18. There are potential exclusions are drug trafficking, sex offenses that are mandatory classification sentences. In Ohio, we have registration and classification that is defined by statute, and if they fall under that mandatory classification status, then they will potentially be excluded. Use of a weapon, serious harm to children, violent offenses with a victim of serious injury. The reason they're labeled as potential exclusions is that the judge has a wide discretion when it comes to admitting or excluding people from the court or from family intervention court. We haven't had any that have come to the point of any of these exclusions that we've had to deal with. We did have one early on, a young lady that was charged with drug trafficking, but when she admitted the charge, it was a reduced charge. So it came in with a possession of a felony possession of a controlled substance rather than drug trafficking. So that made that part of it a little easier. The clinical criteria must have a mental health substance abuse diagnosis or identified family difficulties. And, you know, to be frank, by the time they get to us, the person making the referral kind of knows the family, and it's not hard to identify families that are having identified family difficulties. The family dysfunction or the struggles in the home tend to become pretty evident, but rarely are they evident when a child is placed on probation or when a charge comes in or a dependency case is filed. It usually takes some time getting involved with families. So the clinical criteria is they must have a mental health or substance abuse diagnosis, must be able to understand and comply with program requirements, must not pose an unacceptable risk to program, staff, family, or community. The program requirements is an important part of this. And you'll see when we get to the statistics, I'll talk about this a little more. But we have a lot of people who talk to the families before they come in. And there's a lot of requirements placed on them as a unit. So we spend quite a bit of time beforehand letting them know what our expectations are so that once they get into the program, we don't end up with a situation where they didn't really understand what was going on. And we've navigated that pretty well so far. It does get a little difficult in the early phases. But so far, people that have come in pretty much understand what's expected of them with the exception of one case that I'll mention in a little bit. But that's eligibility standards. The referrals can come from anyone on the treatment team, and actually anyone that's connected. So we have probation officers and other court staff. We have caseworkers that are not involved in family intervention court that are in job and family services and children's services that will make referrals. But what happens is a referral is filled out, and it's a pretty detailed referral sheet. And they will come to court for disposition. I noted on here that it's generally a disposition of last resort. And we try to stick to that because if there are ways to get things straightened out without going into the in-depth process that family intervention court is, we try those. Sometimes, you know, there's mental health counseling that people will respond to that won't require us to get involved to the extent that we need to. So when we finally do make a disposition saying they're going into family intervention court, it is a disposition of last resort. Sometimes it'll be the last thing before permanent custody action is filed, or the last try before the kids are removed in a dependency case, in a delinquency case, before they get sent to a community control facility or placed in a out-of-home placement. We try to use this to avoid those situations that none of us want to see. The coordinator performs all the screens and assessments that she can. Some of them are referred out and we get outside assessments and referrals, or outside assessments and screens. But for the most part, this is all done pretty intensely here in-house. The participant and family agreement is reviewed with the defense bar representative. The attorney sits down and spends quite a bit of time with them, making sure that they understand both of the agreements that need to be executed. And then after all that's done, if they are still with it, if they have not said, no way, we're not going to do this, then it's presented. But that is only after all household members consent to being an FIC. And the reason that's important is if we don't have a buy-in across the board, then there's really no point in going through all this. If there's internal resistance, if there's someone who doesn't think that it's worth it, then it really kind of defeats the purpose. But many times what we're seeing is the families, when they get to this point, they know they need something. And they have exhausted their skills to be able to fix it themselves. So this is where they come to. Once coordinator completes the screens, attorney reviews agreements. The case is presented to the treatment team. Treatment team either votes to admit or refuse. Generally speaking, I can't speak to our refusals because honestly, by the time it's gotten to that point, everybody that's been presented has been admitted. The reason for that is that they've gone through such intensive screening that we pretty well have a good idea of what's going on by the time it gets to us. But as part of the rules of superintendence, the judge has the final say. Judge can overrule our vote to refuse admission, or he can overrule our vote to admit and say that the family is not admitted in family intervention court. So I want to talk briefly about funding. For those of you who are trying to do any of this work, you know that funding can be kind of difficult, and we've been able to put this together without too much additional funding, and it's been neutral on our general fund here in the county. But our primary sources for funding are the 4-County Adams Board. That's the mental health board here in Northwest Ohio. It's we generally do things here in this area with 4-County, the 4 corner counties in the state, and they provide some funding for what we're doing. We get a small payroll subsidy from the Ohio Department of Mental Health and Addiction Services. That coming into this year was cut in by more than 50%. So that kind of, we took a hit on that a little bit. But we're also working with community money, and the last bullet point, I know the community members make in-kind donations. And we're also getting some support, a little bit of support from our United Way here in our county. The way we handled it internally was we just reallocated staff. I mentioned that the chief probation officer, we kind of peeled traditional probation off of her, and she is just handling FIC cases. We were afraid that it was going to increase the function of the other probation officers in our office, but it actually has kind of leveled out and hasn't had near the impact that we were concerned about. And but it's freed up this probation officer to really do some important and valuable work. The only real major extra cost that we've seen is the amount of drug screens that we use. Based upon the rules of superintendence, we have to screen heavily and frequently, and in addition, we're also screening members of the family. So before, this wasn't something that we were expecting to have to do when it came to planning for how Family Intervention Court was going to operate. I want to talk a little bit more about the in-kind donations. Being in a community like this, we're able to get out, by we, it's kind of a collective universal we because members of the court don't do this. But I want to talk a little bit about the Reclaiming Future structure. We have as part of our structure, a community fellow who is a member of our community who works with raising money and raising and getting in-kind donations. So when we have a family and intervention court, we get things like donation of sheets for bedding, pizza coupons, gas cards, different things like that we can give to the families, either to help them do something or have them do something as a family. You know, the gas cards can get them to appointments. We do not have any public transportation here. So we may have families that have to drive 20, 30, even 40 miles to get to any appointments that we require them to go to. So having gas cards. You know, a lot of these families, they don't spend time together. They don't go out to eat. They don't have family game night. So we try to come up with ways that they can engage in those ways that we weren't able to before. And I apologize that I stammered a little bit. I guess there's a question that I wanted to address, asking if we screen all participants or just the identified juvenile. Generally speaking, we screen the adults and the juvenile. If there's multiple kids in the home, we don't generally do an assessment or screen on those other children. For instance, if it's a delinquency case, when the child comes to us, we do a couple screens immediately as just part of our structure here at the court. If the referral is made, we do additional screening assessments on the juvenile and on the parents, so that we can kind of get an idea of what we're dealing with. And I'll give you an example of how that works. We had one case that they finished up about a year ago, I believe. The mother, when we did the assessment on the mother, there were some things that came out in the assessment that were concerning, so we sent it out for a full mental health assessment. And then she ended up going for a psychological assessment. Come to find out, she had a personality disorder for which she was able to receive treatment. And that, when she got treatment for that, it changed the functioning of the home. So that's kind of how and why we approach it that way. But getting back to the funding issue, it's really important to understand that in this process, we had no idea what expenses we were going to have. We had no idea what kind of obstacles we were going to run into, whether it comes to people who had insurance that was too good, and so we couldn't get them treatment, to families that had no running water in their home or functioning gas or a running car, or any number of different things. Because what happens in these cases is when you pull back the cover, you pull back the cover on their lives, you get to see a lot more than what you ever expected to see. And so these in-kind donations and small monetary donations that we get from the community really help us address some of those needs when they come up. And we take the philosophy that any obstacle to this family getting better are obstacles that we need to address. So it gets pretty broad in some of the things that we do, although we try to keep it under control. You progress through family intervention court through phases. We cleverly named them phase 1, phase 2, phase 3, phase 4. But phase 1 is our compliance phase. We develop treatment plans, identify services, all the things identified here, but the central point of the compliance phase is to settle down the chaos in the home. Many times these families, when they come in, their life is complete chaos, and we struggle against this idea of overwhelming them with requirements while at the same time trying to settle down the chaos. We had, and I'll talk about this family a little more when I get to the statistics, but we had one family that we never could get them to settle down from the chaos. It got more and more and more chaotic as time went on. But in other families, it's come in and they've been very, very chaotic. They were able to stabilize, and once they were able to stabilize, we were able to focus in on what was really going on. It's kind of like when you injure a joint and it's swollen, the doctor can't really see what's going on until the swelling goes down. It's the same kind of concept here. So we try and get them settled down and complying with the basic rules of the court. And once we get through phase 1, that's weekly review hearings. Then we move into phase 2, which is every 2 weeks. But we start identifying long-term goals. We start to identify if we're missing anything, engage with more resources. The primary idea being to get the family engaged in services. So phase 1, you settle them down. Phase 2, you get them engaged. And that's why we call it program engagement.
Excuse me, Jerry?
Yes.
This is Jim. We have a question. If parents are pending their own criminal case, do the same qualifiers apply for eligibility, and does the parent's attorney participate?
That's a good question. We haven't had that happen yet. If in the event that it does, I can see that there would be no issue with if they wanted to participate, we would allow the parent's attorney to participate as well, because the last thing we would want to do is do anything to harm their due process rights in a pending criminal action. So we would take great care in how we handle that. Are there any other questions, Jim?
Not at this time.
Okay, all right. So in phase 3, it's the growth and development phase. And we look for improvement. We look for improvement because of all the engagement that went on in phase 2. And in phase 3, we expect to see the change. We expect to see the result of some of the change that we've been pushing for. And they come to court every 3 weeks. Phase 4 is our maintenance phase. They come to court once every 4 weeks. And really, we look to see if they can maintain when the strings are loosened, because a lot of times what we're seeing is they'll do really good, they'll do really good, they'll do really good, and as we start to step further and further back, they start to regress back into what they're doing. And part of it is the structure helps them. It's not, it's not a knock against the participants, but when you settle down the chaos and you start to pull back, then sometimes family will drift back into chaos. So whatever that chaos may be, however it appears. So we try to keep a close eye on them on the review hearings. But even in phase 4, the program coordinator and the probation officer for delinquency cases, or the case manager and dependency cases, are still pretty heavily involved. Not as involved as they were in the early phases, but they haven't stepped out completely. They're still meeting with their case managers or probation officers, whatever the case may be, on a fairly frequent basis. So we're not just kind of stepping back and leaving them hang out to dry. After 90 days of maintaining, once review hearings cease, there's a graduation. And the way we do graduation is we kind of have one event every few months and bring people together and bring the participants in that are participating at the time, along with the people who have graduated. And it's a way to kind of connect these people to each other. The goal would be that the participants see the results, to see how things kind of come out in the end. So, those have been, or the last one we had was pretty well attended and was a really, the people had a really good time.
Quick question, Jerry.
So, yes.
The duration of each phase, is it a set period of time?
It is not a set period of time. Generally speaking, phase 1 is about 12. It's about 12 weeks is the goal. I think we have one right now that is at 26 weeks, but we're seeing progress, and we've actually considered moving that one into phase 2. But they all generally run about 3 months apiece. Is kind of the idea. Sometimes they can move through quicker, sometimes they're slowed down, but that's the target at least. Any other questions?
Yes, one more. What does phase 1, settling down the chaos, look like, and how does that look different from phase 2 engagement, behavior-wise, in the family?
Okay, I have a really good illustration for that. We had one family that was a dependency case that did not successfully complete. It's the only one that only case that we've ended up removing from family intervention court. What we do in phase 1 is we have them set appointments and make the initial appointment, or set an assessment and make the initial assessment that they, their kids are going to school. The kind of baseline things. We had one case, the one I just mentioned, where the basic goals we had for the parents were to show up to your appointments, don't cuss out people, show up to court, and I think, if I remember right, there was a doctor's appointment we wanted one of them to make. I think they hit all of their goals one week. And then after that, it just completely fell apart. So that one never got out of phase 1. That one was a really difficult case. But it's the calming down the chaos is just getting those initial things done so that they can engage. So there's a big difference between the two, and it's not as easy to describe as it is to witness, to be honest with you. Are there any other questions?
That's it for now.
Okay. So far on delinquency side, we've had 30 cases reviewed or referred. We've accepted 16. Of the 14 not accepted, 2 didn't want to consent to the process. And we had 2 that went into residential treatment. We've had 3 of the 16 that have come into FIC receive charges. I believe 2 of them were felonies, if I'm not mistaken. But none were removed for receiving new charges. And that's something that I really wanted to spend more time on, but I'm not going to get to. But when we look at lessons learned and takeaways, part of this process is really rolling with the punches and not holding these kids to and the families to an expectation of 100% compliance, because when they come in, they're not even close to that. And understanding that we're going to have some slip-ups along the way has kind of allowed us to show some grace to these families when a lot of them have not experienced it. We've had 4 female, 2 male, 14 Caucasian, 2 African American. I do want to mention we have a minority population here in Ohio, or I'm sorry, in Williams County, that is statistically negligible. So, meaning they don't really measure the schools and so on and so forth because they have such a small minority population. So that discrepancy there is not unusual for our demographics. We've administered 327 drug screens to juveniles, only 11 positive screens. We've given 39 to adults with 7 positive. We did have 1 juvenile receive new charges after graduation. In the dependency cases, we've had 7 referred, 3 accepted. The 4 that did not come in did not consent to the process. I mentioned the case that we had removed. because they couldn't get past phase one. They just could not get engaged at all. That case also, they received a criminal charge, but that was not the reason we removed them. The drug screens, we've had 30 given to adults with 3 positive, 14 to juvenile with 0 positive. So those are kind of the baseline statistics that we've seen so far in the 2 years we've been operating. Lessons learned. I want to kind of focus in on a couple of these. First of all, dependency cases, if you do this work at all, you know dependency cases are very, very difficult. If you can get the family engaged, if you can get the parents engaged in the process, then we start to get good results. And I know that sounds really basic and simple, but if you worked in these cases, you know that the biggest reason that they're there to begin with is because they don't want to engage. And we struggle with motivating the parents. We still have an issue with lack of services. And I don't believe that we've engaged our community resources at the level we'd like to see. That's something that we really need to work on and develop better. Our takeaways, a big part of anything specialized docket or problem-solving court is the non-adversarial approach. And that really permeates what we do and how our team works. We tend to focus a lot on the system and how that impacts the household. What happens by that is we are actually seeing positive results. We had one family that after they graduated, the family was, the husband and wife relationship was a disaster. It was absolutely horrendous. And we were able to get them settled down, and after they graduated, they got a divorce. So, you know, we're not here for marriage therapy, but their divorce was amicable, and which was remarkable because when they were in our program, they were throwing stuff at each other in front of the family therapist. So we really got things settled down there to the point where they were able to make responsible decisions. And, you know, the household structure, I don't think there's any way we can get around this household structure, and focusing on that seems to have a dramatic impact on the drug use. I mean, several of the kids that we have right now, their primary presenting problem was daily drug use. And I mentioned earlier, we've learned to kind of roll with the setbacks. And there was about a month there where my chief probation officer walked into my office and she said, FIC is a disaster, it's failing, it's not working, everybody's screwing up. But we were able to take a step back and kind of let the process work, and it worked. So taking that long view is kind of difficult, and you struggle with it because you want to be reactionary and you want to force compliance because that's what we do. That's what courts do. We say you're going to comply, you're going to comply, you're going to comply. And backing off of that idea and working in a almost, I hate to say it this way, but a collaborative way with the families and the household systems tend to get better results. And you know, you have to ask yourself, and this is something I ask myself a lot in this process, is what is our goal? Is it compliance or is it integrated change? Our system is designed for compliance. I make the comment here often, we can get compliance if we need to. We can get kids to comply. We can get parents in dependency cases to comply if we need to. We'd prefer not to, because if we can get integrated change within the household, then we can actually make an impact on the outcomes. And hopefully it'll be a generational outcome. So that's all I have. I guess we need to start dealing with questions.
Yes, Jay, thank you. We have a number of questions. I'll start with the first one. What evaluation instruments have you found effective with your population?
We started out on the delinquency side. We started out using the GAIN short screen and using that only. We have since switched to the Mazie system, or Mazie questionnaire, because it's a little easier for the kids to respond to. It also has some trauma questions, which kind of helps us zero in on some things. We do use a Ohio Youth Assessment tool developed by the Department of Youth Services here in Ohio that measures criminogenic risk. Other than that, for the adults, then we rely on our GAIN assessments, which are not administered or not designed to be administered by a licensed therapist. You kind of collect the information, plug it in, and it generates a report. And these are just the basic tools we use to identify need. We also use the GAIN short screen after or as they're coming in for admission. So we have the screens that we use when they come to the court, and then we have additional screens that the case manager uses. And then we also attempt to get mental health assessments as quickly as we can. And we have agreements with our mental health providers that if we make a referral, they get right back to us right away.
Okay, thank you. And then the next one is, are there possibilities to link graduates to or from a support group in the community?
That is our plan. We haven't developed that yet. We have, I think, 9 graduates so far. So we haven't really taken the steps to do that, but that is something that we want to do. We also want to connect parents with other parents, and that's part of what we're doing with the graduation ceremony, because families that have already graduated come back also, and we have seen some connections developing there, but admittedly it's not something we've developed as well as we need to.
Thank you. And a couple of related questions. If family members are screened for drug use, are there consequences for them for relapse, and how do you handle positive adult drug screens? Does this affect the child's progress in the program?
If it's a delinquency case, we do not punish the child for a parent's failed drug screen. What we've done so far, and thankfully we haven't had to deal with it to a great extent yet, but we kind of let the therapeutic provider, the service provider, take care of the consequences. For instance, this isn't a delinquency case, this is a dependency case where they've recommended that one of the parents go into residential drug treatment. That's going to become that is a recommendation now of the treatment team, but that came through the service provider directly. That wasn't something that we generated on our own.
Thank you. And what rewards or incentives do you offer for motivation?
A wide variety of them. One of our most popular ones is just candy, kind of an attaboy. But when the advanced phases, we give gift certificates to go out to dinner. For instance, there's a couple restaurants here right by the courthouse that we get $60 gift certificates, and the family can then go out and have a family meal together. We also have family fun packages that we'll put together. You know, if somebody like we had one of our students who was the case was first came to us as a truancy, and it quickly escalated into delinquencies last year or last spring, and she just received Student of the Month award at her school. So we gave her a pizza coupon, you know, as an attaboy. So it's a wide variety of things. We also have things for the parents, kind of lotions and things like that they can pick from, so that we can show their appreciation. And it's important, from our perspective, it's important to do that for the parents in delinquency cases and the kids in dependency cases, because this is a family thing. This is not just focused on one or the other, but we do not punish kids for parents not complying or vice versa.
Thank you. And someone has asked if you could please clarify your definition of dependency case. Our
dependency cases are, and I kind of use that as a broad broad term. In Ohio, it's abuse, neglect, dependency. And it's cases that are with our Children's Services Division in which they've filed a complaint with our court alleging either abuse, neglect, or dependency.
Okay.
And Jerry, I'm just going to jump in. This is Elkin. I want to note for folks that this particular model, the general framework that you're using, is most often used around the country for the abuse, neglect, dependency cases. And I would refer folks who are interested in exploring that particular use of this model to the Children and Family Futures website, cffutures.org, for more information about that, and as well as American University's website from their Justice Center has some stuff on the Family Treatment Court. Just to chime in, that this model is actually most frequently used. This is, from what we know, the only known application of this model for juvenile drug court type cases. So it's more common than this particular application. Okay, Jim, I'll grab another question.
Yeah, a couple related questions here. Can you say more about families' roles in setting goals versus what the justice system wants? And what does collaboration with families look like?
Kind of the second part of that question kind of links both of them together. Whenever our program coordinator goes out to set up goals, we try not to dictate what those goals are, because every situation is different. You know, it might be, it might be as simple as using an I like book, so that you know, where you have phrases in there, I like this about you. So you kind of teach a family how to communicate more positively with each other. Or it could be setting alarms. It could be cleaning the house. It could be, it's really dictated by what the family needs are. And we try not to, and I should have used the word dictated, because we're not really dictating to them what their goals are. The program coordinator sits down with them to find out what their needs are, and then we generate goals based upon that. Try not to be too, try not to dictate too much to them.
Thank you. Are there any family-based intervention services or supports that all participant families received?
Yes and no. We have a therapist that goes into the home. However, I mentioned in one of the slides, I think I mentioned, maybe I didn't mention it, but we struggle with service providers here. We're in a fairly remote location. However, I'm in the process right now of working with a service provider and the 4-County Adams Board that I mentioned earlier, where FFT is going to be linked into what we're doing now. However, what we've done so far has just been home-based therapy, a loosely based family counselor, and cobbling together a family coach to try and cobble together what we're doing so far and developing this. But we should have FFT available to us in the next few weeks.
And for those out there who don't know what FFT is, that's functional family therapy. It's one of the tried and true evidence-based family therapy models that are out there, and with good evidence and support in this population. It's relatively inexpensive to train for and to implement and sustain. Some of the other structured family therapy models are prohibitively expensive and difficult to implement, but FFT is one of the good ones.
And that's why we selected that, because, you know, funding, as I mentioned, is an issue. So we try and keep it as close to the vest as we can.
Okay, another question is, this program sounds great, but doesn't seem like it would be accessible to some of our higher risk kids, as their parents would not likely comply with treatment. Am I right in thinking this is a program for kids and families who are moderate risk?
I can see that to a degree, but and I can only speak to what we've done here, but if the approach is right, I think that when you talk to families where you have kids that are in that fall into the high risk category, and I'm assuming that means criminogenic high risk, the families know that they got to do something different. And if they want to do something different, then I think that this program would work. I've seen low risk, I've seen moderate risk, and I've seen high risk, all three, where they just didn't want to be bothered with it. So I think that I wouldn't exclude high risk. I can see how that possibility would happen or could occur, but I do think that if a parent wants to engage, then that's a step in the right direction.
And this is Evan. I'll jump in to say that I think one of the historical barriers that we have had in the field in juvenile treatment court settings is that our assumption that certain parents don't want to be engaged and our lack of these kind of collaborative, inclusive options for how we begin a conversation with them has really been a barrier to even getting family engagement off the ground. I think we assume that families are the problem and that they don't want to come in. And you'd be surprised, and I think we have been pleasantly surprised in observing this experiment in Northwest Ohio with the level of engagement and a sigh of relief that you get from families that you typically would have written off out of hand because they just look like the kind of family that wouldn't be able to cooperate with, with the theater of juvenile treatment court the way we have it structured, which is not so welcoming to families. This is sort of a radically inclusive way to include families. Other questions popping in, Jim? You want to?
Yeah. Are all drug screens random?
Yes. Yes, they are. We were just informed that there's a program we could actually plug people's names into, and it generates a random list. But we do not announce drug screens. Kind of pop in at the home and pop in at the school and perform the screens.
Okay. And do you use juvenile detention or jail as a sanction?
I would love to say no, but we do. We are, and I should say as a sanction. It's not necessarily as a sanction. It's in escalation situations, safety situations. We still use the same criteria that we would use if we detained a juvenile who, we get a call and they committed a theft offense and they have, that's probably not a good example, a breaking and entering where they have no place to go. They're carrying, there's issues of whether they were carrying a gun or not, those type of things. One of the programs that we're actually working on developing now is stepping even further away from using detention as a sanction and setting up a network of respite homes so that would be our first option to put a child in respite rather than ever using detention for it. I wish I could give you a better answer than that.
Thank you. And what are the legal benefits of successful program completion for adults and for youth?
For youth, the charge is sealed and expunged. With adults, because of our reporting system in the state of Ohio, when it comes to abuse, neglect, dependency cases, we're not permitted to do anything like sealing and expunging.
Thank you. And are there any mental health diagnoses that would exclude a juvenile from participation in the FIC?
I think the only diagnosis that would exclude a juvenile is an incompetency diagnosis, and that's only a possibility. And that's only because of their ability to engage. We have a case right now where we had a young lady that was just, we tried every behavioral modification trick we could think of, and by we I mean the treatment team and the service providers and family coaches. I mean everybody that we could bring into this situation. We finally sent her out for a full psychological assessment, and it came back that she was on the autism spectrum. So it has completely changed the way that we approach. We're retraining the parents. We're engaging differently. The whole process is different. But even even that was not one where we said, oh, well, she's autistic, we can't have her in here. We look for ways to improve the situation for everybody.
Thank you. And a couple more. TFCBT, I'm sorry, I'm not familiar with the acronym. TFCBT, is it offered?
No, I'm not familiar with that one either. So no, it's not.
And is there a structured family therapy model that the counselors are using?
We're told yes, but that's why we're bringing in FFT, so that we have that for all the families that come into FIC.
Mm-hmm. Do you foresee accepting any unofficial court cases just open to children's services?
I don't believe so, no. If they're not filed with the court in an official capacity, then no.
Can you say more about the family coach?
We have a service provider here that provides a family coach that goes in. I think she's going in 3 times a week, an hour at a time, and works with them on developing plans for cleaning schedules or communication strategies. How to get kids up for school in the morning, just some really basic, things. And it just so happens that the family coach that we're using in one case also has an autistic child, and they're the family coach that's working with the family that just had the child diagnosed with autism. So, and this girl's 13 years old that just received that diagnosis. So, that's another advantage that we have to having family coach in.
Thank you. What might be the sanctions for a parent who fails a drug test?
We don't know. That's one of the areas that we really struggle with. We generally leave it up to the service provider because if they test positive for drugs, we will refer them out if they're not already receiving counseling. As I mentioned, we had one earlier that she's going to residential drug treatment. That I would not label, though, as a sanction. The responses are based on a therapeutic model, not on a compliance model. And so far, we haven't had too much trouble with that, although, if it comes up, I'm afraid of what it might do. I mean, we do require more frequent reviews, possibly, so they might be coming into court more frequently, and we'll increase the drug screening. So I guess those would count as sanctions.
And do you have stats for recidivism?
Just the ones that I posted. We had 3 out of the 16 commit new crime, and the one that was removed from FIC on the dependency side ended up with a permanent custody finding, so the custody was granted elsewhere. But those are the recidivism stats that we have so far. We don't file probation violations, and we don't file probation violations. So that wouldn't. When we talk recidivism, it's only if they pick up new charges.
Good. And another question is, can you explain better how the dependency cases are handled and referred? Do children attend even if younger?
Generally speaking, first of all, the referrals come from either, so far they've come from either the prosecutor or the caseworkers at Children's Services. We generally, if the kids are younger, we generally do not require them to come because it can be disruptive and counterproductive. But if they're old enough, I think we've had them come in as young as 7 or 8 when they're in the home. And sometimes, when they're young like that, we may have them come in once every few weeks once every few reviews and not every single one. But on the flip side of that, it can be a practical concern because a lot of these parents may have to bring them because they don't have other child care options. So we don't bar them from bringing younger children because then it becomes a problem of getting them there to begin with.
Mm-hmm. And relates somewhat to the next question, transportation to court and other various appointments is often a problem for participants. How is this need addressed in FIC?
And I do want to circle back to answering the previous question. If the child has been, if the child is out of the home, sometimes we do have kinship placements or something of the kind, then they are not required to be there. It would just be the parent or parents. But could you repeat that last question? I totally.
Yeah, no, it's transportation to court and other various appointments is often a problem. How do you address that?
We address it various ways. To be honest with you, sometimes we've had court staff go or children's services staff go pick them up and bring them. We've provided gas cards so that they can afford to get there. And we've also adjusted schedules at times to try and help them maximize their attendance. And there's also even been some carpooling that's happened. We tend to have groupings of families, and we actually have a couple that are related to each other. So they can sometimes get there together.
Another question is there a reason you don't have school personnel on your team?
No, there isn't, and it's not intentional. We actually work extremely close with our schools. There has been some discussion about bringing them in, but from a practical standpoint, it's kind of difficult since we have 7 different school districts and a standardized treatment team. So we wouldn't know really what school representative to bring in. But on the flip side, our probation officer works extremely closely with our schools. They have a great deal of input in what we do, and they're heavily involved in what we do. They're just not in the treatment team.
Good.
Oh, and we also have one thing I would like to point out that I didn't get to mention earlier. We have a system in the county of care coordination. We have social workers that work with with families in the schools, and we work closely with them. They identify needs to connect families with needs that are outside of our court system. But then they also can be our eyes and ears inside the school as well.
Another question is, are you using instruments to measure change over time in mental health, substance abuse, and family functioning?
The quick answer is no, we are not. I would like to, but we're not right now.
And I think we may be getting to the end of our questions. It's great to see all these questions.
Yep.
How do you deal with perceived issues with ex parte communication?
There's a couple different ways of looking at that. The first is we don't have discussions about cases without both attorneys present, especially when we're dealing with any type of possible sanction. We've had to clarify our defense attorney role pretty clearly so that he doesn't end up dealing with a conflict. The prosecutor's office and the defense bar work together pretty closely in how they handle these cases so that we avoid both actual ex parte and any perceived ex parte. And also it's specifically spelled out in our participant handbook and program description that they can bring their own attorney to the hearing if they choose to do so.
Great. And do you just provide the services to the immediate family, or are other family members included if they live in the same household?
Everybody in the household. So if grandma and grandpa are in the household, then they're included as well. There are times that we've had extended family move out. We've had them move out because they were resistant and kind of in the way. But that's been pretty rare. Yeah. That includes boyfriends, girlfriends, and basically anybody in the home.
Now, I think that we've reached the end of the questions that I can see, but I want to make sure there have been so many. I want to make sure I haven't missed any, and so at this time, I think I would invite, if you have a question that has not been asked or answered, I would invite you to use *6 to unmute your line to ask your question.
And Jim, I think we can also, if it turns out we missed a question or folks want to email us, I think we can get into an email dialogue with folks and follow up as well.
Okay.
Terrific.
So Jerry, if you would advance to our last slide.
I think I did. Yep.
Okay, good. I want to just thank everybody. What a very robust Q&A. We're very happy that that took place. And inside of a lot of those questions were what I see as some great practice improvement suggestions, like follow-up assessments throughout a process to track change. Lots of really good thoughts and ideas. And to the extent that a webinar can feel like a discussion, this really did feel like a discussion. And I just want to wrap up by saying that we really are at a very positive crossroads, I think, as a field, both from a government funding standpoint and the practice communities out there, like in Northwest Ohio, where we're really taking a close look at what works in this idea that I brought up earlier of therapeutic jurisprudence. How do we really bring about healing and wellness for kids and families in a court setting, which can often kind of work against itself and be somewhat of an oxymoron. And the field has really committed to looking at what works and getting creative. The new guidelines that have been released for juvenile treatment courts are intended as a set of principles to really kind of compel and motivate the field to get creative in how they bring those things about. And one of those vexing problems we've been facing for years is how do we really include families in a process that is not particularly family friendly. And while this is not a perfect experiment, what Jerry and his colleagues have done in Northwest Ohio is really test a hypothesis about what if we radically include families and think of the whole system and think holistically for cases that we otherwise would assign to a treatment court, which in many ways, without being too critical of the framework, we spent a lot of time trying to make an adult model, a very individual model work for adolescents. And based on what we know about adolescent brain development and the importance of the family, a model like this is really critical to think about, or pieces of it that you may be able to incorporate into your current practice. So thank you, Jerry, for bringing some exciting ideas to us and for being a partner with Reclaiming Futures. Stay tuned. Those of you who are interested in hearing about future webinars, sign up for our newsletter. We have a webinar planned for February without a firm date yet, looking at trauma and healing in the court setting with young people and families, kind of from a social justice and angle of looking at the role of race in the way that we have been thinking about and talking about trauma as a field. So stay tuned for the announcement on that webinar, which will be a collaboration with the National Child Traumatic Stress Network, an organization which many of you know. So do sign up for our newsletter. Again, the recording of this webinar will be posted shortly on YouTube. And if you'd like a copy of a PDF copy of the presentation today, email our administrative person, Kate Knappett, at the email address on the slide here. And again, thanks everyone for attending and for sticking it out nearly 30 minutes longer than planned for the Q&A. Thanks all, and have a good afternoon.